Okay, so good morning, everyone, and welcome to our third edition of the Small Business Support Series. Thank you all for joining us, and thank you to the Department of Labor and Advanced Education for supporting the full week of informational sessions. I'm Cindy Mann, Member Services and Business Development Specialist here at the Halifax Chamber, and your host for today's session. We're looking forward to hearing from Labor Services Branch on the labor standard issues that Nova Scotia businesses have been navigating during 2020. We will learn key labor standard issues with which employers should be familiar, as well as the specific employment questions that have been raised by the COVID-19 pandemic. Feel free to type any questions into the chat box and we'll answer them as time allows. It's now my pleasure to introduce Cynthia Yazbek, Executive Director, Labor Services Branch with the Department of Labor and Advanced Education since 2015. The branch is responsible for administering minimum labor standards and protections for employees, delivering coalition and mediation services to unionized workplaces, representing injured workers and their families, and hearing and adjacent workplace disputes through the Nova Scotia Labor Board. Welcome, Cynthia, and over to you.
Great, thank you very much, Cindy. Good morning, everyone. I have a few comments by way of introduction before we jump into our slide presentation. But perhaps first of all, we just wanted to start with a quick poll just to ask the participants, just to get a sense, I guess, of our audience and whether our participants would identify themselves as either a small, medium, or a large business. So I think that Cindy, you're gonna launch that poll question for our participants to respond? There we are. Okay, well, that's helpful. We've got everybody on the call identifying as a small business. So it's always really helpful for us to understand our audience as that may change somewhat the kinds of issues that you might be dealing with. So that's great to have that information up front. So we are happy to be here to discuss labor standards in 2020. Perhaps like no other year in recent history, when we simply reference 2020, I think that takes on a particular meaning for employers, for employees, for Nova Scotians. It's been a year of navigating the employment rules and issues that employers routinely face, as well as, of course, doing our best to address employment situations in this pandemic and applying our employment laws in that context as well. Just to give you a few statistics I think it's helpful in understanding the kinds of issues that our employers and employees have been facing over the last number of months. In the period of mid-March to October, so essentially when the state of emergency came into play until last month, our division received about 7,100 inquiries during that time. 2,200 of them were COVID related and 4,900 were more routine questions about employment standards that we would typically receive. But in the early days of the pandemic, not surprisingly, about 80% of our inquiries were all related to the pandemic. And things began to level out in July, I guess, when some businesses started to reopen and our public health restrictions started to ease a little bit. And by July, we were receiving sort of 70% of inquiries we would typically see, and only 30% of our inquiries were COVID related. So 2020 has been truly a challenging year for employers and employees in this province. And while we hope that our epidemiology continues to be as it has been, it is incumbent upon us to understand our employment laws, our rights, and our obligations in order to navigate whatever scenario may unfold over the coming months. So to that end, we're going to spend the first part of our presentation, our time together, discussing the more fundamental and routine labor standards laws and issues with which employers must be familiar. And then we will focus on the specific provisions that relate to the COVID-19 pandemic. Unlike other provinces, we did not pass any new labor standards legislation or regulations during this pandemic, we have been able to respond within the context of our existing laws. So we will highlight the emergency leave provisions and other relevant sections of our code. And then at the end, as noted, we're really more than happy to take any questions that you might have. So next slide, please. So just some general information to start. The Labor Standards Code and the regulations under that legislation apply primarily to two groups. The first is employees who work for provincially regulated businesses. So any employees who work for federally regulated industries such as postal services or banking, transportation, those individuals are covered by federal employment laws. All of our provincially regulated businesses are obviously covered by our legislation. The second group of workers that are covered are foreign workers that are recruited for employment in Nova Scotia. And these workers will often have other protections as a result of agreements with the federal government, with their country of origin and their employers. But the Labor Standards Code also applies to these workers. So if you employ temporary foreign workers, it's important to understand that piece. It's also important to keep in mind that the Labor Standards Code establishes the minimum standards in Nova Scotia. Many employers will choose to compensate with a higher hourly rate or salary and with richer benefits, but the code itself provides for the absolute minimum which is required by law. Now that said, we do have some exceptions to these minimums, which are set out in our regulations, and that really is because we've got different rules at times for different types of work that are required. An example of that would be that our code's termination provisions do not apply to people who are employed in the construction industry. Another example, which many of you may be familiar with, is some of our provisions do not apply to unionized workplaces, as their collective agreements may address particular provisions rather than the code provisions themselves. So those are two examples that may be familiar to you. Next slide, please. The work of the Labor Standards Division at a very high level is to administer the Labor Standards Code and its regulations. In doing so, the work of the division really focuses on four main areas. The first is information and awareness. So education for both employers and employees is a key part of our role. We do try to focus on ensuring that the rights and responsibilities of employees, foreign workers, and their employers are well understood. So our team presents, as we are today, information sessions. We create plain language materials. We reach out to stakeholder groups to help us facilitate and support the division in reaching out to employee and employer audiences. Our experience is certainly that the more we educate and the more we have employers and employees operating in the province that understand our rules, the level of compliance correspondingly increases with the level of education. So it's a key component of the work that we do. The second is dispute resolution. So our division receives approximately 1,000 complaints annually. Primarily from employees, but also some from employers. And we work with employers and employees to resolve the complaints. So that can look a few different ways. It could mean that an employee ultimately, after some discussion with the division, chooses to not proceed with the complaint. They withdraw their complaint. It could mean that one of our officers works with the parties and they reach a settlement agreement that works for both parties. Or it could mean that our team has to investigate a complaint, make a decision on the merits of the complaint, and then either dismiss the complaint, concluding that there's no merit, or to order payment or a resolution of some other kind. So dispute resolution is a key and probably the largest piece of the work that the labor standards team does on a day-to-day basis. The third piece, which is important to understand, is the inspection and audit component of the work under our legislation. The division does have the authority to inspect and audit employers. This sometimes occurs in response to concerns that have been raised by the public, or sometimes it is just a more targeted audit to assess how a particular sector is doing in terms of understanding and complying with our legislation. There are times as well when we may ask employers to do a self-audit to identify any areas of misunderstanding or misapplication or non-compliance with the minimum standard required by law. We do, in the context of our audits and inspections, really do use that as an opportunity to work with our employers, to educate, to bring awareness to the rules and to the laws, which sometimes are not all that straightforward for smaller businesses that are operating in our province. So that is, I will almost put the audit piece and the education awareness piece very much go hand in hand, and we try to educate as much as possible as we conduct our audits. And then the last piece is around foreign worker recruitment, licensing, and registration. Our legislation sets out, as I noted, specific rules relating to foreign workers. So employers who wish to recruit foreign workers for employment in Nova Scotia have to apply for an employer registration certificate from our division. We conduct a review of the employer's practices and make a determination as to whether an employer registration certificate should be issued to the employer. As well, third parties who want to help employers to find foreign workers have to apply to the division for a recruitment license, a foreign worker recruitment license, and employers who choose to use a third party to find foreign workers must use a licensed recruiter. So if you are an employer that recruits foreign workers through a third party, they have to be licensed with our division. So with that, I am going to turn over the next few slides to my colleague, Lynn Hartley, who is our Director of Labor Standards. So I will turn it over to you, Lynn. So I am just going to mute myself here.
Good morning. I've just adjusted my volume and I've taken myself off of mute, so I hope everyone can hear me well. These next few slides will highlight some of the main provisions under our legislation. We will focus on the general rules in relation to these provisions. As Cynthia noted, there are exceptions to many of the rules. The first slide you see there is with respect to wages and protection of pay. The legislation protects employees' wages. Wages include salaries, commissions, compensation, and any form for services measured by piece, time, or otherwise. The definition of wages would encompass non-discretionary bonuses, such as performance-based bonuses. Wages do not, however, include gratuities. Most employees must be paid at least minimum wage, and the current minimum wage is $12.55 an hour. When there are changes to the minimum wage, those changes happen April 1st. Employers must pay employees all wages earned at least semi-monthly and within 5 days after the end of the pay period in which the wages were earned. When employers pay employees, they must make sure that they're giving employees a pay statement. If an employer provides electronic pay statements, they must give the employees confidential access to their pay statements and a means for making a paper copy of those statements. We regularly receive complaints from employees about not receiving pay statements with their pay, or about their pay statements not containing the required information. Pay statements must include certain information, and that includes at a minimum the period for which the payment of wages is made, the number of hours for which payment is made, the rate of wages, details of the deductions made from the wages, and the sum the employee is receiving. Earlier, Cynthia talked about the work the Labor Standards Division does. She talked about circumstances where we might find a violation of the code and we might order something. We might order payment if the employee is owed pay. If we're finding that an employer is not complying with certain areas of our legislation, like the requirement to keep pay statements, and through our work with the employer, we can't get them to a point where we're confident that they are going to provide pay statements as required under the code, We will also do what we call an order to comply. So sometimes we'll issue an order to comply to an employer that simply says, these are the rules, you must comply, you must provide pay statements. There are rules regarding what deductions can be made from an employee's pay. In many cases, unless a deduction is made pursuant to a statute, so for example, the Income Tax Act, or a court order, such as a restitution order, it cannot take an employee below minimum wage, and it can only be done if the employee has clearly agreed to the deduction. Now, there are some exceptions to this. In some cases, when an agreement is required, it must be in writing. The rules regarding deductions can be confusing, including for us within the division. We need to look at not only the legislation and what's prescribed there in the code about deductions, but we also have to look to case law to try to identify the rules for the various kinds of deductions an employer might make. The code and regulations also set out rules for overtime pay, which is a form of wages. There are different rules for different industries and different types of employees. The general rule is that employees are entitled to 1.5 times their regular rate of wages for hours worked in excess of 48 in a week. For employees to whom this rule does not apply, we need to look to the regulations for rules. For example, the minimum wage regulations that apply to employees who are employed in construction and property maintenance work. Those regulations provide that employees earn 1.5 times their regular rate of pay for hours worked in excess of 110 hours averaged over a 2-week period. I should also mention a new provision of the code that came into effect. I believe it was in March of 2020, and Cynthia will correct me if I'm wrong about the date. The code now provides that employers cannot prohibit employees from discussing their wages or the wages of other employees in the workplace. And this is a change. Some employers rely on that rule. They make it a rule about confidentiality, and they advise employees that they can't talk about their wages. There's now a law in the legislation that says they can. And the reason for that change was in large part, if employees can't discuss their wages, then they can't identify whether potentially they're not receiving equal pay. And there are rules in the legislation about equal pay for work that is substantively the same work. It provides that you can't discriminate against employees based on gender and provide them different rates of pay because of their gender. The next slide talks about general holidays with pay. There are 6 general paid holidays, and they're listed on the slide. The top bullet lists those ones that are the holidays that are set out in the Nova Scotia Labour Standards Code. The second bullet notes that Remembrance Day is not a general holiday. Remembrance Day has its own piece of legislation, the Remembrance Day Act, which sets out different rules than the Labour Standards Code does for holidays. And the Remembrance Day Act includes rules about a period of silence, what types of businesses can operate on Remembrance Day. It has certain rules about hours of operation. It also has a holiday with pay provision, but that provision is different than the general holiday provisions in the Labour Standards Code. And I'm going to focus with this information on the general holidays in the Labour Standards Code. As a starting point, employees must qualify to be entitled to a holiday pay benefit. And there are certain criteria they have to meet in order to qualify. They must be entitled to receive pay for 15 of the 30 days immediately preceding the holiday. We emphasize that the code uses the language of pay, not wages. And this means that the employee doesn't necessarily have to work 15 of the 30 days immediately before the holiday. If they have paid sick time that their employer as a greater benefit provides to them, or if they're on vacation days during that period, vacation time is paid time under our legislation. That time would be counted towards the 15 of the 30 days that they have to demonstrate they're entitled to receive pay for. In addition, they have to work their last scheduled shift before the holiday and first scheduled shift after the holiday. And we emphasize the word scheduled. It doesn't mean the day before and the day after the holiday. So if the holiday is on a Saturday and someone's last scheduled shift before the holiday is Thursday and they work that shift, they're meeting that criteria. If an employee works for a continuous operation, and when we think of continuous operations, we think of operations that operate essentially Monday through Sunday, and they operate regardless of holidays. We think of, for example, gas stations, convenience stores, restaurants. There's another criteria that they need to meet. If employees of continuous operations are called upon to work on the holiday, but they don't, they won't qualify for holiday pay. So once an employer establishes whether an employee qualifies for one of those 6 general holidays, and they determine the employee does, the next is to look at what kind of benefit does the employee receive for working for the holiday. And there are 2 examples here that I wanted to address. One is a situation where an employee does not work on the holiday. So they've qualified for a holiday with pay, but they don't work on the holiday. If they don't work on the holiday, and that holiday falls on a non-working day for them, so let's say the employee never works on Sunday, and the holiday falls on Sunday this year, and they meet the criteria for qualifying, then because that day falls on a non-working day for them, the employer must give them another day off with pay. If Sunday is their normal work day and they're going to get that day off with pay, then the employer's met their obligations. That employee's gotten the day off and they've gotten pay with the day. The second example I wanted to focus on was situations where employees work on the holiday. If an employee works on the holiday and they're not employed in a continuous operation, the employer must, and they qualify for a holiday with pay, the employer must give them a regular day's wages plus 1.5 times their regular rate of wages for the hours actually worked on the holiday. And hopefully this example will be helpful for folks. Employee normally works on Mondays, and they normally work 8 hours. Labor Day is on Monday. The employee qualifies for the holiday. They work on the holiday. So they must get 8 hours as a regular day's pay for the holiday, plus, in this case, they only work 4 hours on Labor Day instead of the regular 8. They must get 1.5 times their regular rate of pay for the 4 hours they work on Labor Day. If the employee works for a continuous operation, they qualify for holiday pay, they work on the holiday, there's a bit more flexibility for employers who operate continuous operations. The employer can give the employee the benefit as I've just described it, a regular day's pay plus time and a half for any hours worked on the holiday, or the employer can give them their regular pay for working on the holiday. So in this example, 4 hours at their regular rate of pay, plus the employer must give them another day off with pay. So they have those 2 options. The next slide deals with vacation time and pay. Employees earn vacation time over 12 continuous months. The employer has 10 months, once the 12-month period is over, to give the employee their vacation. Employees with a period of employment of less than 8 years must receive a minimum of 2 weeks vacation, and that would include 4% vacation pay would go along with that. Once an employee completes 8 years of service, they must receive a minimum of 3 weeks vacation under the code, and that would be 6% vacation pay that would go with that. Employees earn vacation pay as soon as they start earning wages. So you hire them, they start working on Monday, they start earning their wages, their vacation pay, whether it's 4% or 6%, or if the employer offers a greater benefit, it could be a higher percentage, attaches to those gross wages. And just a reminder, the wages include, for example, non-discretionary bonuses and commissions. Once an employee has completed 7 years of employment, they begin earning 6% vacation pay on the gross wages to go along with the 3 weeks vacation time they're entitled to once they complete their 8th year of service. And this can be a bit confusing for employers the way our legislation is worded. We try to explain these things a little bit more clearly in our guide to the code, but the key point is once you've completed your 7 years, you start earning your 6%, so you have that to go along with your 3 weeks time once you've completed your 8th year of service with the employer. Many employers offer more vacation than the minimum, and Cynthia touched earlier on greater benefits under the legislation. So an employer might offer 4 weeks vacation, 8% vacation pay. If there's a dispute around the employee being owed vacation pay or time, we can get involved in that dispute and we can enforce the greater benefit as it's set out in the agreement between the employer and employer. If it's clear that the employee is owed 8% in 4 weeks, we can enforce that. If it's not clear what that agreement is, our practice is to default to the minimum requirements in the code. You'll note on this slide, it talks about how vacation can be paid out. Some employers pay it out on each pay. So the employer will have an entry on their pay statement. It'll show their wages, their deductions, and it'll also show an entry to say, this pay period, they got $84 in vacation pay, and that was paid out to them this pay period. Employers are permitted to do that. Employers might accumulate it. So it's almost like bank that they see on their pay statement that shows it just increases with each pay period, with each additional gross pay to get paid. Some employers will include it in the rate of pay, and we see that in certain industries, and it may be that from an employer's perspective, it's a little bit simpler, just include it in the rate of pay, so they're going to pay employee $20 an hour, and that includes their vacation pay. Employers can do that. We just caution them, if vacation pay is included in the hourly rate of pay, the hourly rate must equal at least minimum wage plus the appropriate percentage of vacation pay, must be clear to the employee that the employee understood it was included in the rate of pay. If there's a complaint and the employer can't provide clear and convincing evidence that the employee knew it was included in their rate of pay, we'll order the pay. So in that respect, it can feel like a bit of a liability to the employer. So we always encourage employers to put that in writing, have employees sign off at the start of their employment, indicating that they clearly understand their vacation pay is included in their rate of pay, if that's how the employer would like to deal with vacation pay. The next slide touches on the leaves under the Labor Standards Code and covers some of the basic elements around those leaves. There are several job protected leaves in the code. Some of the newer ones are domestic violence leave and critically ill adult leave. Emergency leave might feel like a new leave because of our current situation with the pandemic, but it's actually been in the code since 2009. And Cynthia will talk a bit about emergency leave in a bit more detail shortly. The code prescribes the conditions that must be met for an employee to qualify for each of the leaves. For many of the leaves, the employee must be employed with their employer for a period of at least 3 months to qualify for the leave. This includes, for example, the critical illness leaves, reservist leave, compassionate care leave. For other leaves, such as emergency leave, bereavement leave, pregnancy and parental leave, employees don't need a minimum period of employment to qualify. The leaves may prescribe when an employer can ask to verify the employee is entitled to the leave. For example, to verify an employee is entitled to compassionate care leave, an employer can ask an employee to provide a medical certificate stating the employee's family member has a serious medical condition with a significant risk of death within 26 weeks. With respect to domestic violence leave, an employer can ask an employee to complete a form that was developed by Labor and Advanced Education to allow employers to very respectfully and in a very sensitive way obtain the information they need to verify in their minds that the employee is entitled to the leave. The leaves are unpaid with the exception of domestic violence leave, and there was a significant amount of consultation around that and social policy reasons for requiring some pay attached to domestic violence leave. And as noted on the slide, it's up to 3 days of pay that goes with domestic violence leave. All other leaves are unpaid. However, many of those other leaves do align with EI benefits. So when we think of pregnancy parental leave, for example, folks who qualify for that leave often qualify for EI benefits to support them while they're on that leave. Employers cannot discriminate against an employee for taking or evidencing an intention to take a leave to which they're entitled. And that's something we often try to emphasize with employers, that they want to be careful, even if they're going through a restructuring and they are looking at eliminating positions. If there's an employee who's on leave during that time that they're going through a reorganization, they have to be careful because under the legislation, they're not allowed to eliminate that employee's employment while they're on the leave. They must wait until the employee returns from the leave, and then if in good faith the employer ceased its operations or eliminated the employee's position and they can't provide the employee with reasonable alternative employment, the employer can terminate the employee's employment when the leave ends, and they must follow the termination rules in the code at that point. I'm now going to turn it back over to Cynthia to talk about emergency leave.
Thank you, Lynn. So I'm just watching the time as well. It's about 10:30. We've got about 5 or so more slides to go through, and we do want to give you an opportunity to ask some questions. So we'll try to run through these in the next 10 minutes or so to provide some time, or maybe we'll even try to I don't want to skip over them too much because they're significant for COVID, but we'll do our best here. So the emergency leave has been the most relevant, I would say, in terms of addressing COVID-19 related issues. So the first question is, when does this apply? This emergency leave is not specific to COVID-19. As Lynn noted, it's been in place for some time. It deals more generally with emergencies, and it applies if a few criteria are met. So if there has been an emergency declared under the Emergency Management Act or a direction or order of a medical officer under our Health Protection Act, or a public health emergency under our Health Protection Act, or an emergency under the federal legislation, if any one of those are met, not all four, but just one, as well as the employees unable to work because of the emergency, or they have to care for a family member that's directly affected by the emergency. So those are basically the two triggers. One of the emergency declarations by provincial or federal authorities, as well as the employee being unable to work or unable to work because they need to care for a family member. So if they meet one of those two criteria, they would qualify for emergency leave. And Lynn is going to go into some detail around some specific examples that you likely have faced during the COVID-19, and that will just be in a few minutes, she will go through those. Next slide, please. So I want to just explain that the emergency leave provision, as Lynn noted, is an unpaid leave. So it means that the employee's job will be protected for the length of the leave, but the employer does not have to provide any pay. That said, there are some federal benefits that may apply. And I'm not going to go into any detail in terms of the benefits, but as an employer, it is important for you to know that they exist and that you're able to refer your employees to the federal government for more information. So there's a Canada Recovery Sickness Benefit. So that is a paid leave benefit, paid sick leave benefit of sorts, Canada Recovery Caregiving Benefit, and the Canada Recovery Benefit. So that information is all online, but if your employers are wanting to access federal benefits, we encourage them to contact the federal government for information. As well, I wanted to just touch on how long does the leave continue? Some employers might be asking that question where their employees are off. Really, it continues for the length of the emergency. So as long as they continue to meet those criteria that I outlined, then the emergency continues, the leave also continues, and their job has to be protected. So there is no specific timeline that sets out 6 months or a year. It's as long as the criteria or the triggers for the leave continue to be met. Next slide, please. In addition to emergency leave, the other leave in our code that really has come into play during the pandemic is our termination and our layoff provisions. So under our legislation, as an employer, you must give an employee written notice of termination or pay in lieu of notice. So one or the other. You can either give them working notice or you can pay them for the period of time that you're required to provide them with notice. And the time that's required is all set out in our code, and it's going to depend on a couple of things. It will depend on how long the employee's been working with you, so their length of service, and it will also depend on if you are terminating more than one employee, or a number of employees, I should say, not more than one, but if you, there's certain thresholds in our code. So if you meet those thresholds for the number of employees that you're laying off, there are specific requirements that go along with terminations of groups of employees. So those are all set out in our guide as well as our legislation. As well, though, important and has become more important during COVID is there are exceptions to when an employer has to give notice or pay in lieu of notice. So if you are laying someone off or terminating their employment rather, and the reason for the termination is outside the employer's control, then that is one exception where you do not have to provide pay in lieu of notice or notice itself. And the other is if you have given the employee a reasonable offer of alternate employment. Whether they accept it or not, if you've made the offer, then you do not have to provide them with pay or notice. And again, Lynn's going to walk you through some examples of the kinds of exceptions which may exist as a result of the COVID-19 pandemic. And one last point before I hand it back over to Lynn, it's important to know that employees who have 10 or more years of service with their employer cannot be discharged or suspended without just cause unless one of these exceptions is met. So unlike an employee who's been working for 5 years, or you can decide that you no longer want them in your employ and you give them the requisite notice. If an employee has more than 10 or more years of service, you cannot do that. You need to have just cause to terminate them, or you can meet one of the exceptions that are provided in the legislation. So with that, I am going to turn it back over to my colleague to finish up our slides.
Thank you, Cynthia. And I'll just add to further elaborate on what Cynthia was saying about the special protection for employees with 10 or more years of service. Yes, an employer absolutely needs just cause to suspend or discharge them unless an exception applies. And there's also case law and language in the code that if the employer is eliminating a position, so if they had 10 positions and they're reorganizing because of difficulties they're experiencing or they want to work more effectively and they eliminate 2 of those positions, the code does allow them, if they're in good faith eliminating a position of an employee with 10 or more years of employment, does allow them to lay off that employee with the proper notice. And again, as Cynthia was saying earlier, some exceptions to the requirement to give notice. So that's just a highlight for us. The language in the code is really important, and looking at the specific words around discharge, suspend, lay off are important to determine like which rule applies in this situation. And our guide to the code does offer some helpful comprehensive information about the various areas of the code, including the situations where employers end employment. The next slide talks about emergency leave versus layoff. And the first part of that is going to be a focus on, I think, emergency leave. Are you on slide? Can you go back to slide 11, please? Thank you. So this has been a challenging era for employers dealing with the pandemic. It's also been a challenging time for our officers trying to navigate through this situation with the pandemic, the lockdown happening, employees not working, restrictions being lifted, employees returning to work. And in dealing with these situations and trying to figure out what is this situation? Is this emergency leave? Is this a layoff? What rules apply in this situation? We always start by trying to identify the reason the employee is not working. And that means carefully reviewing the Health Protection Act order to determine if they're not working because of that order. And that's one of the triggers that Cynthia had identified when she touched on emergency leave. If employees are not working because of the order, they likely qualify for emergency leave. And while the situation might feel like a layoff situation, those employees would actually have job protection if the emergency leave provisions apply to them. We have some examples here of where employees might qualify for emergency leave. For example, we know that during the lockdown, many businesses, such as gyms, hair salons, were required to close under the Health Protection Act order, and their employees were not able to work remotely. That's an example of where the emergency leave provisions would come into play to give them job protection. Or an employee is diagnosed with or awaiting test results for COVID-19, and they're required under the Health Protection Act to self-isolate or self-quarantine. They can't work remotely while they're self-isolating, then the emergency leave provisions would apply to them. The third example here is schools and daycares were closed at a point. There were many employees with children who could not work because they needed to take care of their children who otherwise would have been in school or at daycare. Even as daycares were reopening, employees may have had difficulty finding care in situations where daycares were offering fewer spots. So again, if that employee was the only person who could reasonably provide care for that child and that child needed care, in most cases we're looking at children under 12, then we would say in that situation you can't work remotely while you're providing care for the child. Emergency leave likely applies to you. The next slide focuses more on the layoff examples. If an employee doesn't meet the criteria for emergency leave and they're not working, they haven't been fired, it's a layoff. It would look like a layoff in most cases. And in that case, we'd be looking to the employer to make sure that they're following the termination provisions of the code. Depending on the number of employees laid off within a 4-week period, Cynthia talked about group notice. So we look at a 4-week period and see how many employees are laid off during that period. If it's 10 or more, then the employer might have to provide group notice instead of just individual notice, and that would depend on the size of the group being laid off. Sometimes employers think notice is not required when the layoff's because of a shortage of work. In many cases, the notice is still required. The exception to that is when the reason for the layoff, as Cynthia said earlier, is outside the employer's control, and the employer exercised due diligence to foresee and avoid the cause of the layoff. and that situation notice is not required. When we're dealing with disputes of this nature, the burden is on the employer to prove, on the balance of probabilities, both the reason for the layoff and that the cause of the layoff was outside of their control. So we have a couple examples here that show when we're looking at a layoff. Hopefully they're fairly straightforward. I won't go over them in any detail, but they're talking about situations where somebody's temporarily closing, not because they have to, but they want to because they want to do some more work around public health measures, or if demand for services are dropping and the employer wants to do reorg, or if an employer is facing financial difficulty and it has decided they're just going to close operations. They're not required under the Health Protection Act, but they've just decided that they've reached that point, unfortunately, in their circumstances where they feel like the business can't be viable, or they think that there's a better option for them to simply close the business and deal with all the challenges around that. Those are the situations where they would be looking more like a layoff than an emergency leave kind of situation. The last slide we have here is in relation to employment records. And this is one that we like to emphasize with employers as well. Employers are obligated under the code to keep records that will allow labor standards to determine if the employer is complying with the legislation. There's prescribed records that the employer must keep. For example, each employee's name, address, date of birth, date they started employment, ended employment, number of hours. Those are all laid out in a provision under the legislation. It includes dates of discharge or layoffs. There are also record-keeping requirements for employers who use recruiters to find foreign workers. That information is also available in the guide to the code. And I think this might be the thing that I want to emphasize on this point especially. Complaints can be filed for different reasons. There could be confusion about whether an employee received pay they're entitled to under the legislation. An employer may have misunderstood how to apply an entitlement, or an employee might be upset about something with the employment relationship and they feel they've been treated unfairly, and they come to our office and file a complaint. Our job is to administer and enforce the code in a fair and impartial manner. It can be challenging to get to the bottom of a dispute. We rely on the best evidence available to decide if there's been a violation of the legislation. In most cases, the law requires that the employer prove on balance of probabilities, which means more likely than not, that it complied with the code and regulations. This might be why sometimes employers feel we're on the employee's side. Often when trying to decide if there's a violation, we must rely on statements about what happened that resulted in the dispute. Having good documentation, whether it's in relation to tracking an employee's work time, confirming payments made to an employee, documenting steps the employer took to address performance issues with an employee, etc., to corroborate the employer's explanation of what happened, can make the difference between finding the employer has violated the legislation and finding no failure to comply. And this is why we emphasize that keeping good employment records can protect an employer. The last slide is simply our contact information. So we encourage employers, if they have questions about our legislation, there's a toll-free line, there's a local line. We have an email address if somebody wants to send us a quick email with a question about our rules, our process. And we have helpful information online. We have a web page with lots of information about employment rights. And on that same site, you can find our guide to the Labor Standards Code, which is a fairly comprehensive document that tries to explain in plain language all the different provisions under our legislation. And that's it.
Thank you very much, Cynthia and Lynn. That was very, very informative and lots of information. As a reminder to anyone, we are short on time, but that's okay. We're going to go through a couple of questions here, and if anyone does need to drop off, then that's okay. I'm going to jump right in here to start our questions. Could you tell me if the registration must be completed for each foreign worker or one per company, and how long is the registration valid for?
Yes, the employer registration to hire foreign workers can be completed for a number of foreign workers. So if an employer knows they want to try to hire 10 foreign workers, they can submit one application to us saying they'd like to hire foreign workers, 10 foreign workers, and the registration is good for a year. So that allows them to demonstrate to the federal government that they've met their obligations under the provincial legislation as part of the federal government's process in terms of giving them permission to hire foreign workers.
Okay, excellent, thank you. Okay, also, I think you touched a little bit on this one, but if you're unfamiliar with labor standards in your office, should there be one designated colleague within the office to go to for questions?
I'm not sure if I'm understanding the question correctly. I know some businesses will have an HR individual within their business who is a good person to go to with questions.
Right.
That individual, if they don't have the answers, we'd certainly encourage them to contact our office. Our resources are a great resource for business. I know sometimes it can be a little frustrating for businesses because they like some certainty, and sometimes we really can't provide certainty. We can just say it depends. But we encourage any small businesses, anyone who they feel that works for their business, who would be a good person to connect with our office when they have questions. We'd encourage them to contact us, and we'll do our best to answer their questions.
Excellent. And I think I want to touch on this one as well, but I think that your answer would be the same. How should employers speak to their employees about labor standards?
I think with employers, it's probably a bit of a challenge at times, depending on how the issue comes up for them. We certainly encourage employers to create a workplace environment where it's clear to the workers that they support the labor standards. They're doing all that they should be doing to make sure that they're getting their proper standards under the legislation, encouraging employees to approach them if they have concerns. If they have concerns, for example, that maybe they didn't get paid the correct number of hours a given pay period, to create an environment where they can have a good discussion about that so that there is no conflict between them. They don't need to come to our office. But we also encourage them if there's confusion, because as Cynthia was saying earlier, the rules can be really confusing at times. If there's confusion, we encourage them to contact us. And sometimes we'll get a call from an employer. We'll answer their question. We'll say, do you want to get the employee to give us a call? And we'll have that same conversation with the employee, because we know misunderstandings can sometimes lead to conflict, and we want to try to prevent that as much as we can.
Yes. Yeah, excellent. So I think that we will wrap up here. We're a few minutes over, so sadly we are out of time. But thank you to everyone for attending our Small Business Support Series this week. And a huge thank you to the Department of Labor and Advanced Education for putting these webinars on to provide our businesses with helpful information and training and hiring incentives, workplace hazards, apprenticeship, and labor standards. Thank you very much. It's been very, very informative all week. So join us again next week for an information session on the Halifax Chamber's Trade Accelerator Program. Learn how the program can help you grow your business through exporting. So thanks everyone. That wraps us up for today's session, and happy Friday. Enjoy your weekend. Thank you.